A Massachusetts doctor, Ingolf Tuerk, who is a well-known urologist who specializes in robotics and was making headlines in Massachusetts for the different cases he had been working on and the different movements he was doing in the medical field. He is now accused of killing his wife after an argument that they had. He is accused of strangling her, and his trial is well on his way as the jury selection has already started. He showed up to a pretrial hearing, and we are going to watch it and see what goes on and what is happening in his soon-to-be trial.
So the motion that I filed, I think was pretty clear. I was looking to introduce into evidence the restraining orders, abuse prevention orders, criminal charge of rape, all of which were withdrawn, all of which were either marital privilege asserted, ultimately resulting in a null pros, or actually the matters being dismissed. On one occasion, a judge refused to allow the null pros, and it ended up where the government had to continue for 6 months to be dismissed. Everything was dismissed. My argument, obviously, is that in this case with the doctor, and what we have agreed, by the way, is that the government is introducing into evidence the fact of the February 3rd restraining order, I believe, that was requested. Nothing after that, nothing as far as other instances of abuse or anything of that nature. So we're dealing with the marriage, relationship, February 3rd restraining order. Then, of course, the rest of it is the flow of the negotiations on the deed, put me on the deed, put me on the post-nup, that type of thing. So in the court's decision, I'm looking at it, and you determined that it's not admissible because the relevance would be de minimis, as it were, compared to the prejudice that would be overwhelming. So my only objection, well, my objection would be to the ruling, obviously, but my concern is I don't understand how the court would determine that Mr. Roca, who is not a major participant in the case as far as credibility, that the prejudice would be overwhelming to the government, as opposed to allowing the defendant to introduce into evidence the fact in the course of this relationship, as in other relationships, that she would, as I would say, weaponize the criminal justice or the court system in the district court to obtain restraining orders, to use that to bargain, if you will, and get something out of either probate court, support, custody, whatever the case may be. So I take issue with the court's determination that it would be horrifically, overwhelmingly prejudicial for me to introduce that into evidence against this gentleman, because I'm not attacking him. My concern is that a jury is able to not try the case, as I keep saying, in a vacuum, that they should know the circumstances of this relationship. They should know that she obtained a restraining order, had him thrown out of the house. They should know that this is not the first time that she's done that she's done that in her other relationships. And as I argued to the court, as we always say, knowledge of a defendant's prior convictions or prior arrests is relevant because it shows their state of mind as it relates to Miranda warnings and things of that nature. So I respectfully do object to the court's opinion. I just wanted to put that on record.
All right. Mr. Monahan, do you want to add anything? Or?
No, Your Honor.
Okay. All right. So I just want to be clear. With respect to the relationship between Mr. Tuerk and Ms. McLean, specifically going back for the 1 or 2 year period, that information, to the extent you can get it in, would be admissible and relevant. The fact that you want to get in her attempts in some cases to get restraining orders against Mr. Roca, as well as a custody order through the probate court, again, I don't see the relevancy of those at all. And I think that's what the Commonwealth argued in its initial opposition and then the supplemental opposition.
I understand, Your Honor, and that kind of dovetails into your comment about the government's motion in limine regarding alleged victim's prior statements as to state of mind evidence, and it was allowed by agreement on March 11th, 25. I apologize, Your Honor. In retrospect, I do have to revisit that in reviewing the motion. And
What number paper are you looking at?
185.
I'm sorry?
185.
All right, let me just pull that out. Margaret, do we have it?
I'm sorry, I was docketing on the 485.
185.
185.
Yes.
I can print it out.
All right, well, do you have a copy you could hand up?
Yes, I gave my copy to Mr. Renfro. Is that yours? Yeah. Okay. Thank you.
All right, thank you.
Thank you.
Thank you. All right, so it was allowed by agreement.
Yes, so I apologize, Your Honor, to revisit that if I may, for the record, please. I would object to that, and the reasons are as follows. Number one, state of mind evidence is notoriously dangerous from the defense perspective, as you can well imagine, because this witness A would be brought into court to testify to an alleged statement made by the now deceased individual, or text message or emails, whatever the case may be. It's an impossibility to cross-examine effectively the statement of the person who is the declarant. In this case, it would be Kathleen McLean. I cannot cross-examine her. I cannot attack the reliability or the credibility of the content, and it allows obviously hostile witnesses to come into court, because we're going to have Mr. Roca, who's now going to be clothed with this eminence that he is a wonderful husband, and he wants to sit here during the course of the trial, and he wants to be presented to the jury as being the grieving ex-husband, when in fact you know as well as I do that that's about as far from the truth as possible. But nevertheless, to have him testify and other witnesses testify, depending on what the government intends to do in their direction, to statements made by Ms. McLean as it relates to the state of her marriage to the defendant, where we have obviously evidence that she went into court, that she got a restraining order on February 3rd, and that he was ejected from the home. The rest of the stuff would be negotiations between the two of them and their attorneys as the evidence develops. But to allow evidence of her statements, I suggest to the court, and we know the Supreme Court has been talking a lot in their decisions, and one of the hot-button issues is confrontation rights under the 6th and 14th Amendment, defendant's rights to confront a witness, and you're basically hamstrung. You can't confront the witness because, obviously, the declarant is not there. So I understand the case law. I understand the courts there. Maybe government might want to offer statements that show deterioration of the marriage, which I would object to.
Spady.
I'll take the argument that the defendant is not offering a self-defense defense and is not going to be requesting a self-defense instruction, and therefore the Commonwealth agrees that we are not permitted to put in evidence of the victim's fear of the defendant. That's a different line of cases, however, than what we cited primarily on pages 3 and 4 of our filing, when we're talking about evidence of the victim's state of mind as proof of the defendant's motive to kill. And here in this case, what we have is the victim and the defendant having had some difficulties in their relationship such that there were ongoing probate actions, there was a restraining order, the defendant had moved out of state, and then they chose to reconcile. And throughout that time period, the alleged victim articulated to third parties that she was uncertain about what to do, that she wasn't sure if she wanted to stay in her marriage. There were times where she did want to remain married to the defendant. There were times that she was hopeful that the marriage would work out and they would continue to be able to live happily together, that she very much wanted her children to remain in the Dover public schools, that she was concerned about their needs, about moving them out of that school system, out of that house. And she shared her feelings about the pros and the cons of reconciling with the defendant. And that was an ongoing issue up until the time of the murder. The defendant talks about it in his statement to the police, so that's coming in. And I don't think that the parties have any disagreement about that. What we're talking about is not just his statements about what she was thinking, and he articulates his perspective on his statements in his perspective on her feelings about the marriage, but also other people providing testimony to the jury about her statements and about why the defendant would have killed her when she wasn't going to continue on in the marriage. And there's a whole line of cases that the Commonwealth has cited where the SJC has said that this is proper evidence. We will not introduce, and we have been clear with witnesses about not referring to her fear. That's not what we're talking about. And so, as such, I would ask that the court allow the Commonwealth's motion in limine.
Okay. All right, let me look at it again, and I'll take it under advisement one more time.
But I apologize, Your Honor, could I also just very briefly note that when counsel is arguing that she wanted the marriage to work out, Your Honor is well aware that part of the evidence is that there was discussion that she wanted to be put on the deed. She wanted him to sign the post-nup agreement. And as counsel indicates that her children like the Dover schools. Yeah, they should like the Dover schools because they went from this little stinky little house in Sudbury and ended up moving into this $2 or $3 million house with the pool and with the backyard and with the waterfalls and the gym and the movie theater and everything else, get him thrown out, and the kids are able to be in this house and go to great schools as they are in Dover. So I don't know what the relevance of that concern is, because I should, as I've pointed out to the court and to the government, while she's ostensibly trying to reconcile and trying to work on her marriage, she's online, as Your Honor is well aware, dating websites, pictures, men working out on their exercise equipment, sending half-naked pictures of themselves to her. She's sending naked pictures of herself to other people. She had no legitimate intention of reconciling with him. She wanted on the deed and the money. That's it.
Do you want to add anything?
No, thank you.
Okay. All right. All right, anything else?
No, Judge.
So in 2020, Kathleen McLean, in February, went to the police, got a restraining order, and had her husband removed from the house on February 3rd. She had cited that he would become violent and abusive and was trying to remove herself from the toxic situation. Well, a fight soon occurred, and he is now accused of killing her. And his lawyer is trying to have parts of that removed from this trial that is soon pending, thinking that it will shade and taint the jury. Well, it's pretty relevant in this case since he is accused of killing her. It's going to be interesting what the judge decides to rule on, but I don't foresee it being completely removed. It's extremely relevant in this case.